administration deal with what your compensation is. That's not up for us necessarily.
Yeah, I'm good, Susan. You don't have to worry about me.
Okay.
Thank you, though.
All right, Allison, we're gonna go on the record. Okay, it's 3:20. The last matter we have, case and or matter, however you want to refer to it, is a matter that has come to us on remand from the Common Pleas Court based on a appellate decision that did essentially the same thing as some other things to the trial court. The trial court then issued an order to us to enter a variance order of this board in accordance with the trial court's decision and the Court of Appeals mandates. So let me read that. It's case number 20-0051 CCP 20 CDF 004102. So those would be what, 20-0051. Is that our number? Okay, that's the Board of Building Appeals number. And then is the CCP and the CDF, are those the common pleas and the appellate court numbers? It doesn't. We know what the case is.
It is the common pleas.
Okay, well, that's who's issued the directive to us. Well, the Court of Appeals didn't issue the directive to us, the trial court did. So, okay, that matter has been, thank you. Yeah, okay, well, this is the CPC. This is, it doesn't matter. The Court of Appeals case numbers 20 AP 576 and the Common Pleas Court number is the 20 CD 4102, which would be the last one on our docket. But in any event, okay, so I think we had this up in Worcester, or in we had this up in Ashland a month or two ago, and we continued it, and I think we wanted to get some advice from counsel, and we did. But so in any event, but the history, to the extent anybody needs to know, is that this board, on a 3-2 vote then, upheld the adjudication order of the Upper Arlington Building Authority Department. I think Brad and I voted in favor of granting the variance at that time. The school board took appeal to that in the trial court, which was the next avenue of relief. And then there was a summary judgment decision that was issued then that indicated that our upholding the adjudication order was wrong. I think that was the way it was, but then there was that order was vacated by the then sitting judge. That went up to the Court of Appeals, which was the next place north. And the Court of Appeals said that then Judge Russo shouldn't have vacated her previous order, which indicated that we either abused our discretion or whatever the issue was, and that the variance should have been granted. So that's what the Court of Appeals said. So new sitting judge receives the Court of Appeals decision and then issues an order that was served on us whenever. I don't have that information in front of me, doesn't matter. Well, we don't need that, so which indicates that we enter an order of this board that would grant variance to the Windermere Elementary School in accordance with the judge's decision. So that's where we are. Russ, you're able to hear me, correct?
Yes.
Okay. So with respect to that, gentlemen, what's your pleasure? Paul, you have some thoughts?
Yeah, if you wouldn't mind, Mr. Chair, I do have a statement I'd like to read.
Please.
And if it pleases the chair, I'd like to submit it as well to become part of the record.
Okay.
Thank you. I have proudly served on the Ohio Board of Building Appeals since 2013, and have been reappointed as the architect member of this board by both the previous and current governor of the state of Ohio. My appointment was confirmed by the Ohio Senate. I'm the most senior member and have been elected as the vice chair of the Ohio Board of Building Appeals. I take the duties and responsibilities of my appointment to this board very seriously. When I consider cases that come before this board, I am duty bound by section 3781.19 of the Ohio Revised Code, which establishes the Ohio Board of Building Appeals. In that section, it states that the Board of Building Appeals, as the agency conducting an adjudication hearing, may reverse or modify an order of an enforcing agency by variance if the provisions of the governing laws will not be contrary to public interests, where little enforcement of such provisions will result in unnecessary hardship. Additionally, as a registered architect on this board, I am duty bound to ensure that any variance considered by this board does not violate the health, safety, or welfare of the general public. In this case number 20-0051 for the Upper Arlington City School District Board of Education versus the City of Upper Arlington Building Department, on June 10th, 2020, the Ohio Board of Building Appeals voted to uphold the adjudication order issued by the Building Department. This board determined that literal enforcement of the governing laws would not result in an unnecessary hardship for the Upper Arlington City School District Board of Education. What the Upper Arlington City School District Board of Education wanted to do at the Windermere Elementary School was to install only restroom facilities that would be shared by both male and female sexes. Testimony presented at the hearing indicated that, to the opinion of Paul Imhoff, the superintendent of the Upper Arlington schools, that quote, gender neutral bathrooms are best for all students, end quote, including paraphrasing from an article in Northwestern Law Review that says, quote, we don't need to classify students based on gender, end quote. The argument presented at the hearing is that the 2018 version of the International Building Code, which has not yet been adopted by the state of Ohio, State of Ohio Board of Building Standards, would allow for the presented restroom facilities design. The argument was very misleading on several counts. First, terminology is very important to this matter. The terms gender and sex are not interchangeable. Both the International and Ohio Building Codes are specific in the use of the term sex to distinguish between male and female, and not the term gender. Gender classification or identity is not a consideration of either building code. Second, the 2018 version of the International Building Code does not outright permit all restrooms to be unisex or, for argument, gender neutral. The 2018 version of the International Building Code would allow, through an exception, to permit unisex restroom facilities to count towards the required plumbing fixture count. The 2018 version of the International Building Code and the current Ohio Building Code would still require restroom facilities to be divided by sex. The new exception would not penalize a building for providing unisex restroom facilities. So in the new code, if adopted outright, would still require separate sex facilities, but permit the inclusion of unisex facilities. The argument presented for the Windermere Elementary School is in effect applying the exception of unisex restroom facilities to all of the restroom facilities, which I do not believe is the intention of the code. Third, the assumption that the 2018 version of the International Building Code would be adopted by the State of Ohio Board of Building Standards without modification. Quite often, the Ohio Board of Building Standards modifies the International Building Code before adoption, and I expect that this particular code section is ripe for modification, especially given this case, and in particular, its application to educational buildings. I completely understand that the Upper Arlington City School District Board of Education wants to be able to provide unisex or gender neutral restroom facilities for use by the students and staff. And this provision should be commended. However, the manner to provide such facilities should not be applied to all restrooms. And this point directly relates to the unnecessary hardship for which we considered this case. The Upper Arlington City School District Board of Education could provide unisex or gender neutral restroom facilities in addition to the restroom facilities that are required to be divided by male and female by both the current Ohio Building Code and the new 2018 version of the International Building Code. And I believe if this type of design was presented before the court, the variance would have been granted. Another point of unnecessary hardship must be stated. All other schools constructed in the state of Ohio have provided sex restroom facilities. The Windermere Elementary School would be the only school in the state to not provide required restroom facilities separated by sex. As such, being the exception is definitely not an unnecessary hardship, and why this board upheld the adjudication order and did not grant the variance. One last point about the June 2020 hearing before the Ohio Board of Building Appeals. The testimony provided was misleading regarding the involvement of the parents in the Upper Arlington School District for this particular issue of having restroom facilities shared by both male and female students. The general involvement of parents for voting for a tax levy to build new schools and to serve on design committees does not translate into a general approval of this restroom design. I do not think the Upper Arlington City School District Board of Education adequately explained this restroom design to the parents. They did not testify that this issue was discussed with parents in any meaningful way, nor that this particular issue was reviewed and approved by parents. The fact that a parent group tried to intercede into the subsequent joint motion for summary judgment emphasizes this opinion. I feel I need to address the decision granting the joint motion for summary judgment, for I think the motion was misleading to the Franklin County Court of Common Pleas. In particular, the filed Exhibits A stipulations of fact are not factual and are really just stipulations of opinion. And in some of the stipulations, they are misleading. Stipulation number 3 is misleading in that it states that communal lavatories are a typical design for elementary schools. Communal lavatories are not typical in elementary schools. Stipulation number 4 is misleading, stating that the Ohio Board Building Code does not differentiate between male and female for the required number of plumbing fixtures. It is true that the Ohio Building Code does not provide the minimum number of required plumbing fixtures for each sex in educational facilities, but it does require that separate facilities shall be provided. Ohio Building Code section 2902.2 states, where plumbing fixtures are required, separate facilities shall be provided for each sex. One reading this stipulation might infer that separate facilities are not required in educational uses. Purposely not including this portion of the code as part of this stipulation is misleading. Stipulation number 11 does not adequately describe how the Ohio Board of Building Appeals considers cases. As previously explained, the variance may be granted if the provisions of the governing laws will not be contrary to public interest, where literal enforcement of such provisions will result in unnecessary hardship. The stipulation is misleading by stating that a variance should be granted if deemed not contrary to the code. Most important to our decision was that the literal enforcement of the code would not result in unnecessary hardship. Stipulation number 13 is a misrepresentation of the decision by the Ohio Board of Building Appeals. This board did not grant a variance because the appellant failed to make a justified case for unnecessary hardship. The stipulation stated that the Ohio Board of Building Appeals decision was primarily because gender-neutral bathrooms do not comply with the building code. As stated previously, gender classification is not a consideration of the code. Stipulation number 18 is a gross mischaracterization of the provisions of the International Building Code, especially as it relates to this case. I explained earlier that the 2018 version of the International Building Code only permits, by exception, the application of unisex restroom facilities to be counted towards the overall required plumbing fixture count. The 2018 International Building Code will still require that separate facilities shall be provided for each sex. Stipulation number 19 states that the Ohio Board of Building Standards will, without modification, adopt the applicable provisions of the 2018 version of the International Building Code into the next version of the Ohio Building Code. This is not fact, and likely the Ohio Building Code will be modified prior to adoption. This stipulation also infers that a variance would not have been required if not for the delay of the code adoption by COVID-19 pandemic. Stipulation number 24, misleading in that though the city did not dispute an unnecessary hardship, it did not testify to any determination of unnecessary hardship. And on my rereading of the hearing transcript, no testimony was given by either the appellant or the appellee that students would suffer an unnecessary hardship. The inclusion that students would suffer an unnecessary hardship was only part of the appeal to the Franklin County Court of Common Pleas and in no part of the testimony presented to this board. Nowhere within the joint summary, our joint motion for summary judgment, or the included stipulations were any facts included or an argument provided for regarding unnecessary hardship if a variance was not granted. All it says is that the Upper Arlington City School District Board of Education believes an unnecessary hardship exists, and the City of Upper Arlington Building Department does not dispute. And this is the central issue for which the Ohio Board of Building Appeals made its decision, as it is required to do by the Ohio Revised Code. So that the Franklin County Court of Common Pleas accepted the opinion that an unnecessary hardship exists if a variance is not granted as fact without any evidence or testimony is quite troubling to me. Even with the misleading stipulations in the joint motion for summary judgment, I would think that the Franklin County Court of Common Pleas would want to understand the basis for the Ohio Board of Building Appeals determination that an unnecessary hardship does not exist before granting its own judgment. As such, is my opinion that the Franklin County Court of Common Pleas should not have made judgment contrary to the determination of the Ohio Board of Building Appeals in this case. Personally, I do believe that restroom facilities should be provided for those students who might have anxiety about choosing either a male or female restroom because of their own gender identity. I do not believe that this anxiety rises to the level of determining that students' health, safety, or welfare are at risk. Proper solution would be that schools provide unisex toilet rooms that are considered gender neutral, in addition to restroom facilities that are separated by sex, as is required by the building code. Forcing all students into restroom facilities that are shared by students of the opposite sex is not a prudent solution, especially if these are middle school students. Additionally, I believe that parents should have the right to determine which restroom facilities in a school are in a school that their children should occupy. Parents should solely make that determination, not the students, and definitely not any school board or a superintendent. And finally, I feel I need to chastise the City of Upper Arlington Building Department. I understand that the building department plans to grant their own variance for the same type of restroom facilities in other new school buildings in the district instead of performing their duty as required by the Ohio Revised Code, the Ohio Building Code, and the Ohio Board of Building Standards to issue an adjudication order. Even if a variance had been granted for Wintermere Elementary School, that variance would not be applicable to other school buildings. Rulings of the Ohio Board of Building Appeals are applicable only to the building on the adjudication order and do not set any precedents or change any requirements of the building code. The intentions of the City of Upper Arlington Building Department are clearly stated in stipulation number 9 of the joint motion for summary judgment regarding these other schools. I also believe that the Upper Arlington City School District Board of Education and the City of Upper Arlington are complicit in this action to evade the requirements of governing law and bypass the Ohio Board of Building Appeals. I intend to make formal complaint to the Ohio Board of Building Standards and the Ohio School Boards Association. For these reasons, I cannot in good conscience and under oath to perform the duties and responsibilities, excuse me. It's for these reasons, I cannot in good conscience and under oath to perform the duties and responsibilities as the architect member and vice chair of the Ohio Board of Building Appeals. Vote to grant a variance for this case. I understand that my vote is contrary to the remand from the Franklin County Court of Common Pleas. If the other members of the Ohio Board of Building Appeals intend to issue a variance in compliance with the order of the Franklin County Court of Common Pleas, I will kindly ask that the chair continue this case one more time so that I may tender my resignation on this board, the governor of the state of Ohio, prior to any such action.
Okay, well, obviously that was eloquent, but I guess we got to see where we are. You know, it's going to be the end of that, regardless of the other substance of it. What Paul's been the most valuable guy on this board. There's no question about that. Does the heavy lifting. You don't want to lose him. But he's indicated that some urgency, as I understand it, that we kick the can one more time to allow him to do what he just said, if we're inclined to grant that or to comply with Judge Munson's remand order. It's you know it's an issue that I guess we're going to have to make a determination on. But what's in front of us and on our lap is her order of December 15th of last year that says based on the Court of Appeals decision, she vacates Judge Russo's November 30, 2020 decision, vacating the summary judgment and allowing the intervention of Jane Doe and others. And she denies the motion to vacate the summary judgment of the intervening appellee Jane Doe and grants the joint motion of summary judgment that Judge Russo issued originally, and orders that the case be remanded to the Ohio Board of Building Appeals for issuance of a variance consistent with Judge Russo's September 15, 2020 decision granting summary judgment. Paraphrase that. So, I mean, that's what we're under some sort of court directive to do that. So let me start with Chip. Where are you on this? What do you think?
I would not vote to reissue the variance or to issue the variance.
Okay. If I were to ask for a vote, we'll make sure I'm clear. If I were to ask for a vote on Judge Munson's remand, you would vote nay.
Correct.
Okay. Paul, you wouldn't vote? I mean, well, let's see where we are. Brad, where are you?
Well, since we're remanded, I would uphold, I would vote for it.
And Russ, hopefully Russ is still. Russ, can you hear us?
Yeah, can you hear me? I just unmuted.
Yeah, no, yeah, we can hear you. Have you been able to hear everything that has transpired thus far?
Yeah, the only thing I didn't hear is Brad.
I would support the court order for the ban. It provides the variance.
Okay. Yeah, my take on the whole thing is I the long and short of it, I've never been so disappointed in the law in my life, to be honest with you. I mean, we're put on this board to make decisions and not be told what to do and how to do it. And basically what Paul said in a nutshell, it made it through 2 judges. And I still to this day don't understand how this all happened and how they can justify putting it back on the board and not making the call themselves, which they have the right to do if that's what they so choose. And if they would have interviewed people and found out that probably someone lied under oath, either with us or in court, if they would have done their due diligence, in my opinion. But after all that's said and done, I would vote to uphold the court order just for the simple fact of it's either that or you resign from the board if you choose not to. I mean, it's just, I don't agree with it. I think it's the board did what they were supposed to do, and I think the board still does what they're supposed to do, but this is ridiculous. But I would vote yes.
Okay, and hey, look, I think it's pretty clear that this is, I don't view this personally as a decision on the merits. And I know where I was on the original decision of the board, as was Brad. And then 3 of our colleagues wanted to hold the adjudication but I don't view it as the merits now. I view it as something that we have to do. But that being said, you know, I don't need to do all this on the record, but sounds to me that, how does this work, Susan, if this were to be voted on? I mean, we're going to consider the continuance request for a second, but nobody wants it to resign. If this were to be, like, how do you put it on, how do you put our signatures on an order?
The order just reflects your
Just so
vote.
this was just like any other order of the BBA.
Well, this isn't going to look like any
It'll
other.
show yays and nays, right?
It has the direction we got. We had to have a yes or a no vote from each board member or from the
No,
board.
but I mean, the order itself, I mean, the record will
Correct.
show it, but the order itself that goes out, that's available to the public, well, it always shows, you have check marks.
You have each member's name and how they voted. Whether they abstained, they were absent, whether they voted yes or voted no, is how the order would look.
Okay, well, yeah, I'm a little reluctant to turn this into something that is a profuse record in the sense that we go much further on this, but if this were to be remanded on a 3-2 basis today, as opposed to on a 3-something basis in the future, do you still want to continue? And you know, I mean, I don't want to, maybe.
I think it's pretty clear from my perspective, right, that the duties and responsibilities of this board would be to do what's required of us and send it back to the board to say we did what we did. They did not look at the hardship issue at all. Nor was any of that evidence or testimony provided in the Trumbull motion for summary judgment. And so a mistake has been made. So I do not want to be part of the Ohio Board of Zoning Appeals in any way, shape, or form, yes or no vote in any way.
All right, okay, I got that.
But if you're going to take that action,
I mean, the problem we have is that we've been reviewed, but we're not necessarily, empowered to review the Court of Appeals of the trial court, notwithstanding our personal beliefs. I mean, that's where, that's a particular version. But I would, look, I'd be willing just out of collegial courtesy to continue the matter, to allow you to do what you need to do, so that if and when this is brought up on remand down the future, you're not associated with it. That's what you're saying.
That's correct.
Well, any of us wanted to hear it, right? But certainly can respect where you are. Chip, you got them all agree. What do you think? Continue.
So I'm going to specifically address counsel since he's sitting here. And I realize this isn't a called case or whatever, but I think between the three attorneys sitting in this room, based on the record that has
Four division counsel.
well, we have division counsel too, my apologies.
Assistant.
In the least offensive terms, we can say that there was probably a mischaracterization of what transpired in the hearing here in 2020. And probably in the strongest terms, it was a fraud upon the court in terms of what was presented. Somewhere in between is an accurate adjective to describe what transpired in the court of common pleas. So that being said, what I would ask of counsel is, because we are not, this board and the AG's office and the Board of Building Appeals is not a party to your case, but that effectively ask Judge Munson to issue the order that you want in terms of granting your variance, because she has that authority.
Let me ask this question.
Because in all respects, from a practical standpoint, what we do doesn't make a hill of beans difference. You already got your variance.
Can I?
You don't have your certificate of occupancy, which raises another issue about your building department, not yours, but the City of Upper Arlington's building department, because they have granted certificate of occupancies to other structures or other buildings in the city that allegedly don't follow the building code. So I'm asking you, from one attorney to another, to alleviate, there's a way to alleviate the conundrum facing, and conundrum's a nice way of putting it, facing this board, but for your client to achieve what they want to achieve, or have already achieved. So thank you.
You were sitting in the cheap seats to observe, but you can enter your appearance if you care to.
I would, thank you. Charles Kirschner on behalf of the Upper Arlington City School District. I would first say, I think it's clear that, certain members of the board have their position. I don't think issuing a variance that's ordered by a superior tribunal in any way reflects poorly on your character and your positions.
But it's nothing to do with it. It has everything to do with the courts telling us that we did not do our job properly. We did do our job properly.
Understood, but it is also part of your job as part of the board's statutory charge to comply with orders of superior. And that's just the bottom line. I'm not going to get in the back and forth about whether or not what we presented in your sense was improper to the court, but I will say that the transcript of the proceedings went to the trial court and the Court of Appeals. They had the full transcript, they were able to review it. So whatever may have been, in your opinion, characterized improperly, they could have double checked against the transcript, but I'm sure they did. So I don't think it's fair.
I'm not sure they did. Well, I can almost guarantee they didn't. Because there's no mention of hardship in the testimony or in the joint motion for summary judgment. And that is the reason why we ruled the way we did.
And I appreciate that, but you also have to understand that the school district went through the process. They didn't just skip any steps. They went through the proper process. They've got their order. And I think the school district has been, reasonably patient, having, received this order back in February. And now we're almost in May. And they still don't have the variance that they're entitled to. So, I appreciate the board's position, but I would ask that, the board comply with the statutory charge and issue the variance.
Yeah, Russ, were you able to hear Tariq?
I was, yeah.
Okay, all right, so I'll make sure you were still with us. Okay, well, but let me ask this question. Does, one of the problems is case is terminated, right? Terminated on the.
And that would be the other issue is, I don't believe we could even, reopen the case anyway.
I think we could reopen it if we voted no and if we called up on a contempt charge. I can hear it too.
Well,
They in court.
yeah, I mean, termination is a stamp, but it gets it off the recording. A or B, they'll reactivate anything. Yeah, well, it wouldn't be, it might be a court cost, I don't know. Well, let me ask this. Paul, if the trial court went to the effort of a one or two sentence order that essentially grants the variance in lieu of this board, what does that do with your future?
That would be fine. If the court wants to overrule us, apparently they did, then let them overrule us, right? And grant the variance. Right. Again, my biggest issue is the order that we somehow did our job wrong. And to me, that is incorrect. We did everything that we were required to do by all judge standards that we have to us. So to answer your question, right, if this was continued and council went to the judge and the judge modified the order and removed the remand directive, I would probably stay on this board.
Well, I mean, that's a high falling in some, for a lot of reasons, in terms of, in the interests of transacting our business, having you around. But I don't know, I can't remember, Janine's left the city. Who's the city attorney?
It's Darren Schulman. I believe he's probably on.
Oh, okay.
No.
I'm just not, I would recognize him if we get his input if he was. But I'm just wondering whether or not, let me ask you this, and this put you on the spot a little bit because you may not know. Because I don't know, I sit on this board, but couldn't the trial court, do you think the trial court could issue the order that then the City of Upper Arlington Building Department issues the permit and the authorization based on the variance in lieu of us?
I don't believe that they could do that. No, I think that the power is solely not this board issue of variance. And again, this proceeding is closed. I mean, it's been resolved for a while. I don't think this is a reflection on any opinion of this board on what's correct or wrong. This is an order. I mean, it's very clear that this board doesn't agree with it, or at least some members agree with it. This is literally a procedural, just stamp it. You've been directed by the court to do it.
Can I say something? This is
Yeah.
Russ.
If the court
In regard to
anything
the,
else against the law, I would not. So that's how I feel on this.
Okay, go ahead, Russ.
I mean, in regards to that comment, that's all great and fine, but our names are on there for the rest of our lives. They're not going to know who the attorney was. So it is very near and dear to our hearts, as you heard Paul speak about.
All right, I mean, yeah, I hear you. I hear you on it.
I mean, I don't know if this would help with it if you put, under protest next to the name, whatever. At the end of the day, we just want a variance.
Well, we could explore whether the trial court would do essentially what Tariq's gonna go back and say is our job, right?
We have division counsel here.
Well, yeah, we don't have assistant AG.
Oh, that's true. Sorry.
Yeah, I remember a 10th district court court of appeals case that goes way back with the double securities case that dealt with, in the Commerce Department, what the extent of attorney-client privilege is among in-house agency lawyers, because they were trying to call in the securities case. In-house lawyer, the defense was trying to call in-house lawyer, but they were securities criminal case. And it is limited, what the AGs are of counsel.
What, let me ask, Carl, let me ask you a question. Why can't, if the school board and the city were so inclined, why can't they submit an agreed amended entry
Okay, but it would say what?
that effectively, instead of remanding it, that the judge issues the, whatever language the city wants to cover its position of saying, oh, well, we can go ahead and issue the variance based on, or issue the certificate of occupancy based on what the judge has said.
Yeah, I was going to object to that.
No, it's an agreement. The city and the school board have gone hand in hand throughout this process, so why can't you submit an agreed entry?
That directs, well, because, all right, so right. So the city is a party, correct?
Right.
And the school board is a party. And the parties would submit a proposed agreed entry, Judge Munson signs, that directs the city of Upper Arlington to issue the variance. So what you're saying.
No, the City of Upper Arlington can issue a variance.
They can issue the certificate of
The
occupancy.
certificate of occupancy, wait a minute. Thank you for clarifying.
Issue certificate of occupancy. She's correct.
Well, I think the reality is that Judge Munson's staff attorney, as a practical matter, even though it's terminated, the call of the staff attorney would probably even resolve a 10-minute phone call to the court with short status conference might accomplish that. But look, I feel like we're under a court order. Yeah, I mean, I agree with Tariq in that sense that, and you said it as well, Chip. I mean, the waters over the dam in the sense that the variance is essentially been granted, right?
Well, yeah,
Got their variance is the term you used. So the issue is out of deference to Paul, who served, he's the longest serving member of this board and really is the heaviest lifter. Do we continue this and perhaps in the interim get Judge Munson's audience, but the parties, we're not a party unless we were to somehow be granted some sort of special status for purposes of a status conference and get it done that way to save a valued board member, or with the cast eye with what Russ has told us and what Brad has indicated and what I've said I would do we go ahead and just move forward today? That's the question, I think. And I think you've again made a record for the school district. So, Russ and or Brad? Well, and Chip, I guess. We haven't heard from you on that either. Conclude business, deliberate and conclude business today, or see if the parties can seek an audience with Judge Munson.
I would prefer I would prefer the parties submit an agreed entry or seek a meeting, a teleconference with the judge.
Hey, Russ,
Can we force that?
we can't force it. No, it'd just be a condition. No, it would have to be, it would be gratuitous on their part. I mean, the school board's won the case. So it would be gratuitous on the part of the school board. But, and maybe, you know, in cooperation with the city, because even though the city and the school board, you know, simpatico, at this point in time, they can't ex parte the judge. They'd have to have the city attorney involved in that process. But I mean, I guess that's where we are, right? I mean, I think we're moving forward, or adjourning today without concluding business and see what happens, if anything, with Judge Munson in her chambers. Those are the two options.
Yeah, that's not true. I mean, my request for continuance is only so that I resign before you make some take action.
Right, but the hope would be that perhaps that audience would happen before you, I mean, you tender your resignation,
It's done.
it's effective immediately.
Yeah.
I suppose the governor wouldn't have to accept it. Right.
If there's any chance we could keep Paul on the board, I would be all for it.
Yeah, right. Ross,
Don't go calling the governor now and tell him you won't accept the resignation, because that'll really throw things into a pickle. I don't know if I could pray enough to get an answer for that one.
Russ, you want to adjourn, set this down? It'll be tomorrow, but what's our next date?
23rd. A week from
That's a week.
today, correct?
I mean, I always, you know, kind of look up to you and Chip as attorneys and Paul with the experience and time, and I don't know what you guys are feeling there. You know what I mean? I would obviously rather it go to the judge and have her, per se, do her job and let her override us if she wants to, and give them the variance. I mean, instead of remanding it back to us and taking our voice away. But I don't know the feeling there and what you guys, you know, I heard Chip and I absolutely, you know, back that up, but I don't know, you know, where it's all at as far as, you know, if there's an option of talking to the judge or not. If counsel there seems to think that's an option or not, or, you know.
Well, I'm not real optimistic that the school board's lawyer thinks that that's a viable option, but you know, re-entries happen all the time, particularly in state court.
I mean, is there a chance we call the AG and ask him?
The AG is not a party. And we're not a party.
Yeah. Yeah, all right.
So these are the problems. We're not allowed to have these conversations in behind closed doors.
Right.
We have to do this out in sunshine, which makes it kind of awkward. Here's what I'm inclined to do. I don't know that I'm empowered.
Well, could you facilitate this, what we're talking about?
Well, that's, you're putting them on the spot, but if you want to answer that, I mean, that's right. You
Not being an attorney, I can ask these questions.
He's right. Well, he's secure. The variances, for all practical purposes, they've been prevailed upon. They just don't have the piece of paper, which is the occupancy permit. The judge has pushed this down to us, which is not unusual, but it's unusual in this case because of the certain facts and
It
circumstances.
is unusual. How long have you been board secretary?
Right, I mean, it's not unusual to move it back down to the original authority or jurisdiction. What's unusual in this case is that, unlike, you know, the Court of Appeals that tells the judge, you have to resentence this defendant. The judge doesn't want to do it, but he has to comply or she has to comply. And they just do it because they're numb to it, because they get the Court of Appeals pushing stuff down to them all the time. What's unique about this is that it's one of the issues that you espoused, which leads me to, if I'm empowered to do this, I would say we adjourn today, reconsider May 3rd, and just hope that the Bricker firm and the city attorney contact the court. You know, now that might resolve in the show cause. I mean, to contact the board's considered this, called it twice, and hasn't acted in accordance with the judge's decision. But, you know, if it spares you resigning, just one pathway, or the only pathway to keeping you on the board, I would do that. What's the second?
City building official can issue the C of O. He doesn't have an order from this board granting variance, but he's got a court order.
Okay, here's what we're gonna do.
No, I mean,
No,
well, option two, we could vote to uphold the order.
Yeah, that's
And then get our day in court too. That way we can sit behind closed doors, but then we're partying now.
You mean to, when you say uphold, you mean to uphold the board's order?
Yeah.
As opposed to the court's remand? Yeah, but you don't have to be, there's enough votes on that. So, again, doing this in sunshine, it's awkward, but I would consider kicking the can to May 3rd, seeing what happens. And maybe, did the AG, did our AG reach out to you either?
I spoke with you, she implied that the variance is getting issued for variance, so I'm a little surprised, but
Okay,
that's the most recent reply.
okay, good.
And when I say spoke to, I
No, but
emailed her.
had there been any contact about getting an audience with the court?
No, but not.
Not with you. Are you the person with the most hands on the case?
For this
case.
record, yeah.
Yeah, that's what I thought. Okay. Okay, well, we'll see. You comfortable setting this for May 3rd? See what turns about.
Yes, and again, it is a little awkward, but just so that we have some type of response or answer and enough time for me to be able to take action so that the next time the case is heard, you guys can move if necessary.
Today's the 3rd, Wednesday.
A week from today.
Today.
Yeah, Tuesday, May 3rd.
Come up with a schedule. Yeah, it is. All right, let's do that. You don't, if you want to appear by phone, if there's even a need to appear, let's set it down for May 3rd. Let us try to get our, let's.
Is there a motion?
Oh, I have to do it. That's why I said it was I empowered to do it, I guess not. All right, is there a motion to continue this particular case that's on our docket under remand until May 3rd?
So moved.
Is there a second? Second. All those in favor say aye.
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 Okay, any opposed? Okay. All right, well, we stand adjourned on that. We'll go off the record. Hey, Matt, I'm in the board building. Feels like clear right out. Okay, cool. All right, thanks. All right, well. you know, whatever your communications are, and we'll deal with it. And I suppose May 3rd, we can't let it go any further. Step, there'll have to be something, unless it's obviated, it doesn't need to be on our document. That's, all right, well, thanks for showing. Okay. All right, so stay on the record. We approve minutes for April 4th, and, what, you want to say?
Only to say that the door does shut loudly, I don't think that was reflected.
No, I don't think so. I think I don't think that was a reflection. All right, so we need to establish dates for June and July. Do you want to do that now? Hey, Russ?
Yeah,
Want to do that tomorrow?
Yeah, let's do that tomorrow. You're probably going to not be with us tomorrow, correct?
I am not.
Okay, we'll get some proposed dates and Susan will vet those with you for June and July.
Okay.
All right.
She's got my June. She knows when I can't be there in June.
Okay.
And Mr. Chair, for tomorrow, I did let Mr. know that I will not be able to attend in person tomorrow, but I will be attending remotely tomorrow morning.
Okay.
And I've got to be out here by 11:30.
Okay.
That seems possible with the time.
Well, we just miscall those Ashland dockets all the time.
Mm-hmm.
Okay, is there a motion to approve preparation and compensation for
today?
For today, all right, April 27th.
So moved.
Okay, is there a second? Okay, all those in favor say aye.
Aye.
Any opposed, say nay. And then, okay, so for purposes of our sunshine, our next meeting is tomorrow morning at 8:30, which would be April 27th. And noting that and noting no other new business except hearing dates that we'll take up tomorrow, is there a motion to adjourn?
So moved.
Is there a second? All those in favor say aye.
Aye.
Any opposed? Okay, we stand adjourned. Thank you, Allison. Allison, what are the chances we get held in contempt? What do you think?
Oh, I haven't. I'll show up though.
Okay, we show up. See you, Russ.
For adjourn.